Hello and welcome to EPR with your favorite environmental enthusiasts, Nick and Laura. On today's episode, Laura and I discuss doing the dishes. We talked to Fred Wagner. I was wondering.
Try not to.
Yeah, we talked to Fred Wagner about Phase II NEPA Regulations, the future of waters of the United States, and we take a look at upcoming Supreme Court cases that will impact the way we do things. And finally, foxes are more like cats than dogs. They are nocturnal, use their whiskers to navigate, and gray foxes can even retract their claws just like cats. Last but not least, in an effort to prove that scientists have a sense of humor, male foxes are called dogs and female foxes are called vixens. So how about that? Who doesn't love that?
That's awesome.
You weren't listening at all.
Busted.
Awesome. Well, for everyone who does hear that, those were pretty cool facts, I thought. So,
nice job, Nick. Fantastic. Keep up the good work.
You know what? Let's hit that music.
NAEP is hosting a special webinar on the NEPA Phase II, the Bipartisan Permitting Reform Implementation Rule, on Tuesday, September 19th at 1 p.m. Eastern Time and 10 a.m. Pacific Time. NAEP is pleased to welcome speakers from the White House Council on Environmental Quality, who will present the recently released Notice of Proposed Rulemaking for revisions to the National Environmental Policy Act. The discussion will include an overview of the proposed rule and questions and answers session. Check it out at naep.org. And finally, yay, today's episode is sponsored by Venable LLP, our very wonderful repeat sponsor. Venable is one of the nation's leading law firms. Venable's management reflects a commitment to diversity and inclusion through a broad category of hiring, training, and educational activities. The firm's environmental practice group works with clients across the country on major infrastructure development, including NEPA compliance and resource agency permitting. Venable encourages volunteer activities in professional environmental associations, as reflected by Fred Wagner's membership on the NAEP Board of Directors. Let's get to our segment.
I mean, it's both wonderful and depressing all at the same time. So, it was really great to hear, the updates to waters of the U.S. and Phase II NEPA regulations and all that. But, his wife retired.
Oh, cool.
And so he actually asked for folks to give him advice about what to do now that he has her there, and he doesn't want to make a honey-do list. He doesn't want to be rude or disrespectful, but hey, maybe get a part-time job. He was really, really sweet about it. So it was actually kind of adorable that he was so considerate of his new situation, and we talked about that for a little bit too.
Yeah, well, that's fun. That's kind of a fun topic. I think when I first started living here with my current boyfriend, is that whole thing of okay, why aren't you doing the dishes? And why aren't you doing them like me? I eat food and then I wash and rinse my dish, because the sooner you wash it, the easier it is to clean. I'm not about leaving something sit and make it 3 times harder for myself later. Right. And then he's more okay, I'm done. And this is going to just go right here. And then someday it'll magically just disappear from the dirty sink and be clean again, because the magic fairy will come.
Yeah.
And I'm that magic fairy is me. And she's not happy when she's having to clean those dishes. Right. So, and then we just talked about how he has man eyes. And he just can't see, doesn't see it. So he looks in the kitchen, doesn't see. I'm I would love to look through some man eyes one time and see what my house looks like, because it must look just so immaculate and pristine and whatever. Because when I look at it, I'm dirt, dust, piles, dirty dishes, laundry. Okay, all this stuff needs to go. And he's I don't know, I don't see it.
I 100% have this exact affliction, and it is, it's real. This has been my whole life. It has nothing to do with who I'm with, where I am, whatever. I cannot see certain things. I try, and I really do want to help. I want to be involved. But at the same time, I'm wait, I'm sorry, you asked me to do, oh, you did. Oh, I'm so sorry. It just, my brain shoots that stuff off into the stratosphere, and it never comes back down to earth again. And I remember, ironically, it was as a kid, I was remember 15 or something. My mom asked me to do the laundry 4 times the same day. And each time I'd forgotten that she'd even asked me. It just was so I also have man ears, apparently. So it's
yes.
not just the eyes. It's all senses are Yeah.
I came back from this trip and he says, do you want me to do anything for you? And I said, no. And then he says, well, how about the laundry? You want me to start the laundry? Sure. Mm-hmm. Did my laundry ever start itself? No. So predictable.
Yeah, that's too funny. But it's exactly, I'm not surprised.
Yeah, right. So yeah, I'd love to hear from people if they have a way to correct this, or if they do have a good situation with their partners on how to, because I think the thing for me is, and I think probably a lot of women feel this way, and I think it's beautifully enacted in the beginning of the movie, The Breakup, where, our agreement was then, okay, well, I just have to tell you when I want the dishes done, or I have to tell you when I want you to take the trash out. But then I'm a nag and I don't want to be telling you these things.
Right.
So back to the breakup. I want you to want to do the dishes.
Right. But you're totally right. I mean, you're totally right. Like, that's one of those things that's, there has to be good communication and good understanding of what you
here's
need.
my advice to Fred. Whatever happens to go onto that honey-do list that he makes or she makes, that you have an agreement on how and when it's going to get done.
Right.
Because having the list is only one part of the equation.
That's so true.
I would say having a list and then having no one do anything about it is probably worse.
Yeah. Oh yeah. Because there's expectations there.
Yeah.
And there's times too, I would say, like, if you have that list, you have the expectation, and you're about to do something, and it's like, well, the other person says, I can help you do that. It's actually just insist. No, this is my responsibility. I don't need you to do this. I need you to rest and relax and do whatever you need to do right now so that I can take this for you. It's kind of like, it's another, I almost gave you a sports analogy, and I'm like, who am I talking to? But yeah, it's like, carrying the football, you give it off, you take it back, you give it off, you take it back. You don't just... Did
you see that, folks? He could not help himself.
I know. I really tried to think of something else and I couldn't. It's, because even then I was like, baton? No, that's also sports. So yeah, I gave up.
It's all good. We all get it. Okay, cool. Well, let's get to the interview, because I'm curious to hear what Fred had to say since I was not there. And then I'll go do some dishes or something.
Sounds good. Hello and welcome back to EPR. Today we have Fred Wagner of Venable LLP and our environmental legal correspondent back on the show. Great to have you back, Fred.
I don't know if I like correspondent or superstar. I forget which one.
Yeah, rock star. I think we called you before. Yeah.
Correspondent's good too.
Yeah, right. Our environmental lawyer rock star. There we go. Yeah, well, how are you doing? What's going on with you? What's new?
I had a great summer. The best part about it, I had a trip to Scandinavia. Oh,
wow.
The first time I'd been to that part of the world. And I got to tell you, all those surveys that find the people from that part of the world are the happiest people on earth.
Right.
I totally get it now.
Really?
Yeah. It's beautiful. It's peaceful. The people are, active and engaged. Their environment, surroundings is just so pleasant and cool. Mm-hmm. Their big cities are interesting and dynamic. It's just a beautiful part of the world.
Oh man, I'm really jealous. I haven't been, truthfully. So where did you end up going?
We started in Sweden, in Copenhagen, and we tootled a little bit east to Finland and Estonia.
Oh wow.
An interesting part of the trip was we were in Helsinki the day before President Biden was.
Oh, cool. Yeah.
Literally the day before. And so as we were going around downtown, they were scouting the presidential palace. Right. And there were people all over. They were doing test runs with motorcycles around the streets. But everybody was still out in the streets and having a wonderful time, a typical beautiful summer day.
Right.
But it was going to be completely shut down the next day.
Oh, yeah, of course. Yeah. So you got lucky.
So that was pretty interesting. They actually rearranged the trip so that we would be in Helsinki before the president.
Oh, funny.
And then we circled back to Sweden and then spent most of the trip circling around Norway.
Oh, that's really cool. So are you a ski person or are you a water person? You do a little bit of both, or?
Well, I mean, we were really into the fjords. This was a trip where we wanted to see fjords and we wanted to see the terrain and the mountains and the water. And we did the whole west coast of Norway. You could tootle in and out, back and forth into different fjords, going to different cities. And it is so picturesque. I can't describe it. You go off the North Sea, you make a right-hand turn into whatever fjord you're nearest, and you could be floating for 2 to 4 hours down a fjord. That's how long it is. And, the coastline is so jagged. And as you're going along, unbelievably, you're seeing these beautiful little homes and cottages, popping up all along the way. It seems like everybody in Norway has a summer place.
Wow.
Where they go. And they're not grand, they're not massive, but they're small places, and they all have a little pathway to a pier for your boat. And they pop up like at every little bend and turn of this fjord. You'll be tooling around, you're staring at a mountainside, and you'll go around a bend, and then you see, a village of 30, 40 of these small summer cottages. And then you'll float a little bit more, and then you see another one. They're all over the place. And some of the towns are a little bit bigger, obviously, but some are not. And you get there by boat. You'll leave from, one of the cities on the west, maybe one of the bigger cities, Bergen, or there's, the roads go to the eastern end of the cities, and you could drive your car in. But it was remarkable to see, and it didn't spoil the countryside or the view at all. It seemed to blend in. It seemed to be part of the whole fjord experience.
That's cool. So is it like a place, because there's certain places that you visit where you could take 1,000 photos from 1,000 different angles and it won't do it justice. Is that what you're telling me this place is?
I mean, some of it actually does do it justice, because it's kind of like if you've been to Alaska and you've seen the Inside Passage, it's kind of enclosed in a way. And so the vistas aren't like when you're looking at the Rockies in America or in Canada, where it's so expansive, and you take a picture, and then when you look at the actual picture, you see the horizon and the mountains. They don't do it justice, as you say. And you want to tell your friends, no, the mountains are actually bigger. They're real mountains.
Right.
It doesn't look that way. But the fjords, because it's kind of like enclosed in a little package, you get the vista of the water and the hillsides and the cliffs and the glaciers, all in a much more confined space. And so when you actually look at your pictures, it's like, oh yeah, it looked like that.
Yeah, right.
The waterfalls up against the mountain, next to the water itself, or adjacent to a glacier, you really can capture it. So far, at least looking at our pictures, they're a pretty accurate sense of what we saw and what we felt. So we're really happy with it too.
That's really cool. That's great. That's great to hear. I'm glad you had a good, nice and relaxing summer. And there's nothing else for us to talk about, right? There's no other. We've been joking about this for like a year and a half. Like, it is the craziest time for us to be talking about environmental policy. And I don't even know where to start, honestly. But like, let's actually go. Before we dive into phase two, the phase two rules, we had a decision on NEPA in June that just kind of, in my mind, came out of nowhere when we had the budget come through. How did that process happen? Did we actually change the way NEPA was done just from that release? And then, we'll dive into phase two after that. But what happened in June?
Well, I mean, the Fiscal Responsibility Act was what was passed. And of course, it's kind of like the Inflation Reduction Act. The title of the legislation doesn't really give you a good sense of everything else that's in there. The Inflation Reduction Act is not all that much about inflation. The Fiscal Responsibility Act isn't all that much about fiscal responsibility, but it was really the culmination of discussions on the Hill about what to do with NEPA and permitting reform. Mm-hmm. And there was a great deal of speculation whether there'd actually be a separate piece of legislation. There had been a proposal from the Republicans, that went pretty far, but it went so far that it wasn't gaining a lot of traction with the folks on the Democratic side of the aisle interested in pursuing reform for renewable energy or transmission lines or stuff like that. And so there was a point where we thought, there was going to be an impasse, there was going to be a stalemate, the parties were too far apart. Mm-hmm. But lo and behold, as the deadline came along to avoid defaulting, remember this was all part of the debt ceiling controversy.
Yeah, that's right.
A subset of the provisions that had been proposed by Republicans emerged as a compromise, and was actually put into the Fiscal Responsibility Act. And for the first time in over 50 years, amended NEPA. Wow. That's the headline. That's the lead of the story. This wasn't like the authorization bills that we've seen, MAP 21, the FAST Act, even the bipartisan infrastructure law, that all had provisions dealing with NEPA issues and permitting issues, but they were confined in some ways to the transportation world or to certain things. No, the Fiscal Responsibility Act amended NEPA.
Yeah.
And that was the stunning development. Nobody thought that people would get to that point. Nobody thought that the Democrats would agree to it, but they did. Mm-hmm. And a lot of the things that have been incorporated into the bipartisan infrastructure law and the FAST Act are now part of the law. They're in NEPA. So the time limitations of 2 years for the EIS, 1 year for the EA, page limitations, that's in the law now. Being able to borrow other agencies' categorical exclusions, not just in the reg, it's in the law. Wow. Defaults over how programmatic environmental documents should be used, how long they remain valid in the law. Mm-hmm. And so that's the big thing. And I think what you're seeing so far, at least, is that the 5-alarm fire that I thought we would see from environmental groups hasn't materialized. Mm-hmm. And that's because the things that they amended were either already being done, part of executive orders, part of the reforms in the FAST Act, the permitting council type work, or they were relatively modest.
Right.
So once you get over the fact that there's a whole group of people in this debate that didn't want to see NEPA touched at all, once you get past that and you actually started digging into the actual things they did, I think people took a breath and they said, well, okay, we're not thrilled with it, but if they were going to do anything, at least we've seen some of the reforms that have been floating around for the better part of a decade or so, have been implemented to a certain extent across the industry so we could live with it.
Right.
But that was the big headline. No one expected Congress to get to a point where they would actually amend, the grandfather of all environmental laws, but they did.
Yeah. And it's funny. So when we say, okay, so now it's law, like to talk about timeframes and borrowing CADXs, stuff that most of us were doing anyway, like you said, but from like from a practitioner standpoint, okay, say that you get a document that is a little too large and it is, or, there's an option to borrow a CADX, but they don't do that. Does that change how the process goes afterwards? So like if you maybe aren't meeting these requirements, is there more teeth to it? Is it more like someone in the legal departments of your agencies will tell you, hey, you got to button this up? Like, or is there some consequence for messing those things up?
There's a couple of ways this is going to play out. One of the things they put into the law was that if the deadlines aren't met and you're a project proponent, you could go to court.
Oh, yeah. Okay.
So if it's more than 2 years and for whatever reason, you can go to court. Now, ask any lawyer who's involved in environmental law and they'll say, yeah, that and $1.85 will get you on the metro. Because, it takes so long just to get a legal dispute resolved. What good is it? Like on, day, 365 plus 365 plus 1, if you run to court and say, oh, they're not done, and then the government takes 60 days to answer, and then you have a preliminary status conference or whatnot.
And by then they're done.
Maybe is that really going to matter? Maybe it could, spur action from an agency that's being recalcitrant for some reason, I guess. But, I'm not expecting this avalanche of litigation from project proponents saying, "Oh my gosh, 2 years is over," or or from community groups saying, "Oh, the EIS is 301 pages" or something.
Right.
Where it matters. So that's one thing. If there's in the law, I think it's never going to be used, or if it's used, I don't know to what effect. But where it really matters, Nick, is the relationship between the federal agencies and Congress.
Right.
When Congress passes a law and agencies don't follow that law for whatever reason, that's not very popular.
Right.
And you can get your butts hauled into Capitol Hill to say, wait a minute, I'm looking here at a report that says agency X, you've prepared 25 environmental impact statements over the past year, and in only 5 of those 25 cases, you were able to finish it in 2 years. What's going on, right?
Right.
Or they could say, we wanted, streamlined EISs, and in all 25 cases, you exceeded the 150 pages. Like, do you mean to tell me, Mr. Agency Secretary, that all 25 of those projects were complex that needed all this extra time? We told you to make them shorter. So
right.
The bigger stick is the Congress looking over the shoulder of the agency to say, hey, when we pass a law, we mean it.
Right. Right.
And at least in this case, and we can talk about this later a little bit about vague congressional action versus clear congressional action, they were pretty clear.
Yeah.
There's a couple of the reforms they put into the Fiscal Responsibility Act that were a little bit mushy, and
right.
CEQ tried to deal with that in the Phase II rule, actually.
Right. Yeah. Yeah.
But for the most part, shall be done in a year. That's pretty obvious what that means. The number of pages,
right.
Pretty obvious what that means. So the big ticket item is going to be a year from now, the anniversary of the act, or, 18 months or so forth, when Congress says, hey, we took this major step. We got a coalition together that got almost 70 votes in the Senate to amend NEPA. That's a serious step. And yet, agency, we're not seeing this, or we're not seeing as much as we thought we were going to see these changes over time. That's where you're going to see it. And then the third place you're going to see it, obviously, is if for some reason these sort of developments or claims that people add to litigation in NEPA cases.
Right. Gotcha.
At least so far, the basic things in the amended statute shouldn't raise new causes of action, I don't think. But, lawyers are creative, I've heard.
Yeah. Well, it's funny because, I think in my head, at least, the idea of having timelines and timeframes is to kind of curb some of the, well, let's just put it out there and see where this goes project. Because, we have EISs that are a decade long. There's other things going on. In my head, it's maybe the agency's not really prepared. So are we going to see fewer of those types of projects? Is this going to limit maybe an agency will think twice before starting an EIS without having done their due diligence prior to doing that?
Or private parties who are seeking federal action are going to wait to request those approvals until they're pretty darn ready.
Yeah, right.
So, when I started practice, I think, I talked to people who were, more seasoned professionals than me, and I was trying to get, their background on how this whole process works. And they would, more frequently than you would imagine, I'd hear from my colleagues, well, we'll have the document on the shelf, and then we'll be able to get to it.
Right.
We'll get the document, we'll get the approval, we'll have it on the shelf, and then we're ready to go. It'll be there.
Right.
No way. That practice is gone. It's not going to be used anymore. So that's one thing. I think you'll see the private parties that want to do stuff wait until you're really, really ready. I've had conversations with Harmony Council recently and other folks on projects, and I hearken back to the Orson Welles, commercial. I don't know if you remember that, if you're old enough, but it was Ernest and Julio Gallo, and the tagline was Orson Welles in all his glory and his deep voice, and he said, "We will sell no wine before it's time." That was the tagline. We will sell no wine before it's time.
Right.
And I use that line, with folks in the federal government saying, this is what it's all about now. We will not submit a permit application until it is ripened, ready. It's matured in the barrel, and you're ready to drink it.
Right.
And the folks on the other side of the phone from the agencies were like, yeah, thank God. This is what we've been asking for all along. And so, this dance that you've seen over the years with your clients, I'm sure, where you submit something and the agency says it's not quite complete. We're not ready to go.
Yes.
And then you do this dance. What more do you need? Tell me how much. And that led to a lot of delays just to get everything going. Now I think you're going to see the pre-NEPA, pre-scoping, whatever you want to call it, processes used as much as possible, not to dance, but to mature the projects, the applications, the proposals, so that when the process starts, it can go.
Yeah.
Right. So that the 2 year or the 1 year, has a reasonable likelihood of being accomplished because of all the legwork that's been done first. And, we saw it over the last several years with pre-scoping, just because people wanted to avoid being dinged for the 2 years. Now that that's when it was a policy under an executive order.
Right.
Now that it's in the law, you bet they're really going to try as much as possible. So when they hit the start line, it isn't like the sprinters when you're at a stop and then you go and hear the gun.
Yeah.
The image you should have in your head is the sprinters have been going around the track
right.
for a lap already. And when they hit the start line, they're already going full speed.
Right.
That's the image you should have in your head.
Yeah.
And I think that's the way NEPA practice is going to evolve now, so that the start line is a start line for a trigger for the dates, but it ain't a start line in the sense that you've been running quite a while already.
Right. That's great. And it's really good to hear too. And I think it blends kind of right into our conversation about phase two. We talked about phase one a couple of months ago, or maybe even about a year ago, actually, now that I think about it. And, we have phase two now. And my first question really is kind of how we blend from our Fiscal Responsibility Act to the phase two release. So when those first changes to NEPA come out, does CEQ get a heads up that that's coming? Do they know that they have to make some adjustments, or do they see it and go, oh, wow, I guess let's address this first and then release our phase two rules?
Well, you remember that we had our friends, Jomar Maldonado, at the last NAEP conference in Phoenix, and his boss, Brenda Mallory, speaking. And my sense from that time period was that it was a whole bunch of wait and see.
Yeah.
So remember, I told you there was some discussions that there could potentially be a separate permitting, reform law. And again, that fizzled out. But then they had this rush to the Fiscal Responsibility Act, and everybody was waiting. Where's phase two? Where's phase two? We were hoping that Jomar and Brenda were going to be talking about phase two in Phoenix.
Right.
And they didn't. And that was because they were waiting for Congress. There was absolutely a sense that something was going to happen. So why rush out phase two if there's something else was going to change? That's clearly what was going on. And my understanding from talking to folks is that there had been a proposal circulated amongst the agencies, but then it was pulled back in anticipation of some congressional action. Then it was revised, sent back out for further review, and then OMB cleared it, finally, and then it came out, at the end of July this summer. So that's what happened. There's no question that's what happened. They didn't want to, release something, then have to retract it and re-release it. So they just waited. So then the question is, how do you morph from, phase one to amending NEPA to now phase two?
Yeah.
And there's two broad categories. One is they repeated mostly verbatim what was in the Fiscal Responsibility Act and stuffed it in phase two. They didn't play around with it. They didn't play fast and loose, with one exception. I'll tell you about that. So that's in the regulation. Simple. If you look what's in the reg, you look at the statute, same words. Right. How hard could that have been? Right. That should have been very hard. But they had to wait. They had to see exactly what was in the law. They didn't know.
Right.
But then there's the whole second bucket, which is the bigger bucket by far. And that's the revisions to the regulations in phase two that retract, revert, eliminate a lot of the provisions from the 2020 regulations.
Right.
And they were very aggressive in phase two, reversing a great deal of those provisions. And, we're in this really bizarro world now where, we talked about the 2020 rules when they came out. It felt like yesterday, but it's not.
No.
They've been in place now for 3 years.
Yeah.
The challenges against them failed. They've been implemented for 3 years, and now we just have a proposed rule. We won't have a final rule until 2024, and then there'll be litigation over the final rule. So the 2020 rules, as amended by the phase one rule, which was not challenged in court, is going to be in place and being used for project reviews for upwards of 4 to 6 years before we get anything finalized with Phase II.
Right.
So it's a really remarkable period where, the proposal on the table reverses, a lot of what was part of the 2020, but the 2020 rules are going to be full force in effect for quite a while still.
Yeah. Reading through the Phase II rules, one of the I guess the things I noticed is it is very clear that 2020, it's almost, I want to call it a rebuke. I don't want to call it a scathing indictment, but it reads a lot like that's exactly what it is. And
I don't think you should shy away from those words.
Yeah. And,
and I think what we've seen already, Nick, is that your impression is the impression that both sides of the aisle have.
Right.
No one looks at that and saying, I wonder what they meant by that. The old joke, two psychiatrists walk down the street, one passes the other and says, hello. And the other one says, I wonder what he meant by that.
Right.
This is not like that.
No.
People know exactly what they meant. And a lot of folks are none too happy about it.
Mm-hmm.
The Republicans who negotiated the FRA that we've been talking about read the rules and they said, what are you doing? How much clearer could we have been in amending NEPA for the first time in 50 years that we wanted, a change in the way business is conducted? We wanted reform. We wanted, the default towards quicker reviews, more streamlined reviews, more focused reviews. And I'm reading this. Representative Graves, for example, who was leading negotiator for the Republicans on the FRA, he's come out and said, I've read this and it doesn't seem like you got the memo. Meanwhile, the people on the other side, Chair Mallory and the folks in the environmental community say, no. We were very careful. We religiously incorporated everything from the FRA. There's other ways that are in there to streamline and whatnot. All we did was remain true to the policy provisions of NEPA, Section 101 of NEPA. And the changes that we made from 2020 are the changes that we felt were inconsistent with the statute, not inconsistent with our policy.
Right.
And, I've likened it to, two trains heading down the same track towards each other.
Right.
Because, when the CEQ says over and over and over again in the rule, which they do, that we're reverting to the original regulations and the intent from the original regulations, or as they say over and over again, which they do, that, reading the 2020 rules, one can get the impression that NEPA is just a check the box exercise.
Yes.
They use that phrase several times. Yes. And so we're taking this away. Or, there could be a mistake that, public participation is just, something should be done. No. To fulfill NEPA, we need true engagement. In fact, they've eliminated the word notice from the regulations in favor of the word engagement with respect to public participation. And then most interestingly, of course, they say, look, NEPA itself says it's an action forcing statute. Well, guess what? They've included in these proposed regulations places with, in places where you're considering alternatives, where you're considering the environmentally preferable alternative, when you're considering mitigation, when you're considering the significance threshold, they've really incorporated the action forcing principle into the regulations. And so, again, the left would say, hey, all we're doing is something that's consistent with the statute, something that had been in place for years. The right says, no way, what you're doing is making a procedural statute more substantive. And that's not what we wanted. You're making it more complicated. You're making it more difficult. And that's just the opposite of what we were hoping for. So that's why I talk about the trains colliding, because I think when you get that's what the procedures are mostly the same. And we talk about specific examples of this, but the philosophical bent of the regulation is not consistent with the philosophical bent that led to the amendments of NEPA. Right.
And I mean, and so I don't even, where do we go from here? Is it, okay, we have the Phase II rules, they're draft right now. I think the comment period ends in a couple of weeks, I guess. How are we going to see, what's our next step? And I definitely want to dive into what's in it, because it's not just a rebuke of 2020. I think there's a couple other fun parts to tease out, but what comes after as well?
Well, I'm fairly confident there's going to be a brief extension of the comment period, first of all. There's been a lot of folks have already requested it, and it's such a major rule, the proposal itself is 235 pages. It touches virtually every section of the regulation. So I don't think there's going to be a long extension, but I think there'll be some. So go through that. There's going to be thousands of comments submitted on the rule, and then CQ is going to have to finalize it. And they're going to be under real time pressure because as the presidential election kicks in 2024, having lived through a presidential election inside the administration, there's not a formal prohibition against finalizing a regulation during a presidential campaign, but it is a very, very strong silent presumption.
Right.
You don't get a memo saying that's it, pens down, because that would be, that would be too much of a crossing the line between politics and policy making.
Of course.
Well, not that line is ever crossed, Nick. No,
of course not.
No, of course. No, but so you don't. It's not that way, but it's understood that the last thing an administration wants is, there's a brand new rule on such and such a thing, and then it becomes headline number one for the opposite side. Say, see, look what they're doing. They're either, again, depending on what it is, they're either deregulating and threatening such and such, or they're overburdening the economy and business, and they're terrible. Nobody wants that. So if I'm right, and there is this philosophical clash over the Phase II rules, CEQ's not going to want to have this finalized like in May or June.
Right.
And then you also run into the problem about the implementation of the Congressional Review Act, where Congress can reverse and rescind a regulation that's proposed and final near the end of an administration. And it's a very complicated law about how many congressional days remain, and you never know how many congressional days remain and that kind of thing. But if you wait too long, at the beginning of the Trump administration, you may recall, Congress rescinded 42 regulations that were finalized near the end of the second Obama term.
Right.
So if CQ waits too long to get this finalized, then they're in jeopardy, depending on how Congress turns out and how the president turns out, that all this work could be rescinded. So they got to hustle. And so if the comment period ends, let's say in October, if I'm right that there'll be short extension, and they get thousands of comments, they have to answer all those comments, review and get a rule out. I mean, some of our good friends that we heard from at our last conference, they're going to have a pretty miserable Christmas.
For sure.
They're going to be working over the holidays to get this done because they don't want to wait. They don't want to wait too long. They want to get it out there so that if there is litigation, it gets done, filed right away, and they want to avoid the potential problems with the Congressional Review Act. So it's going to be a busy fall for the folks at CQ in the White House to sort through all the comments, and they're going to be vigorous comments.
Of course, yeah. I mean, I think considering the scope and scale of it, I would be shocked if there weren't. But okay, so it is huge. It is very big. It is a big change. There's a lot in there. So I don't know, give us a couple of nuggets that you really like that you saw, some trends. Maybe we already talked about page limits and stuff like that, but what else did you see in there that maybe is worth?
Some of the really good things that I think are incorporating best practices that we've seen with COVID and the pandemic is this new notion of what public engagement really means.
Yeah.
It's kind of surprising that this has been the result. You thought that COVID could have been a real challenge, it would have made it worse. It made it better. It forced agencies to get more agile. It forced them to get more creative. It's not just going to be a public meeting, but there's going to be virtual meetings. There's going to be pop-up meetings. There's going to be community events. There's going to be smaller gatherings. There's going to be greater outreach to significant stakeholders. Public involvement improved as a result of COVID.
Yeah,
it's crazy, but it did. And I think what people have started to realize is that, for a whole bunch of reasons, that level of true community engagement is better from an environmental justice perspective. It's better from the NEPA process perspective because you're airing and hearing these things kind of sooner and better. You're actually able to incorporate some of this stuff into your final project. So CEQ has taken those principles, excised the notion of notice and public notice, elevated the notion of public engagement, and I don't think you're going to see any pushback at all on that.
Yeah.
It works.
Yeah,
it works.
It does.
It's
I totally agree.
Better. And it doesn't extend the time at all. It just changes how agencies do their job with reaching out to the community. And, like you and I have talked about forever, there's only two purposes of NEPA. One is better decision making, and the second is public participation. And we've seen advances in making public participation better. The regulations reflect that. That's a good thing. It's going to stick. And I don't think even the most ornery person who felt that, the Phase II rules were, awful is going to find too much at fault here with the engagement principles because, gosh, they just work.
Right. I totally agree.
On the other hand.
Yes.
On the other hand, some of these principles of action forcing have now been incorporated in writing with how agencies deal with the sort of the big picture items under NEPA, alternatives analyses, impacts analyses, and then mitigation. What's an example of that? So climate change. Climate is now incorporated as one of the issues that should be addressed. Yeah. And in the context of alternatives, Nick, the way it's stated in the regulation is that you should be considering alternatives that can reduce climate effects.
Right.
As a specific thing. So it isn't so much like, I've got three alternatives. I wonder what it means for climate. No, under these regulations, it's pretty clear the way it's written that if you have a series of alternatives, if one of them doesn't necessarily address, climate and how climate's supposed to be done, you should be going back and doing that specifically.
Right.
And so, in theory, you could have a range of alternatives that's 3 long, and then you may need to go back and say, I'm going to be doing one more now because I have to contemplate an alternative that deals with climate and addresses it in a certain way. Same thing for environmental justice.
Yeah.
So it's adding this, substantive consideration for specific resources, climate, EJ, socioeconomic, and putting it into the definition of your range of reasonable alternatives.
Right.
And that's, agencies haven't thought that way. Project proponents have not thought that way. They thought about a range of alternatives in a whole variety of ways, but not that way, not specifically addressing a particular issue.
Right. So it's interesting you bring that up too. I definitely noticed that in reading through it. And it just says that they'll address it. And I don't know if they should be getting more specific about how they do that or not. Is that really for each agency to decide what that means? Or is that are we going to get more guidance on that over time?
Yep. So you're talking about how climate and EJ, for example, should be incorporated into these analyses. Well, Of course, on the climate side, we had the GHG guidance in January of 2023, which, by the way, still has not been finalized.
Right.
As we sit here now, there were lots of comments. CEQ said they'd be issuing a final one. They haven't. And that was very controversial because people were saying that the specifics were, more onerous and it was going to create more opportunities for mischief and all the rest. But the regulations sort of incorporate by reference some of those principles. So at least for climate, I think there's an understanding, at least from this administration, about the kind of things that you should be doing. And we're seeing enough in the courts. A recent DC Circuit case, dinged an agency for not being specific enough and not doing a quantitative analysis of certain climate effects. That's, I think, spelled out a little bit more clearly. Environmental justice, on the other hand, is not. And it is the nexus between, your typical kind of demographic type analyses that we've been doing for years. But what's obvious from these regulations is that EPA wants you to do, CEQ wants you to do a more substantive analysis now.
Yes.
In the context of cumulative effects. And whether that means you're looking at public health trends, whether you're doing a health impact assessment, whether you're diving kind of more deeply into a particular resource of concern, whether it's air quality or exposure to hazards or water quality or other sorts of concerns, they're wanting to do more. And as of yet, they haven't defined it.
Right.
And in fact, the other day, those of you listening to NAEP should be tuning in and trying to get the recording of this webinar that we did just a couple of days ago, updating environmental justice trends, federal environmental justice trends. We talked at length about how EPA has interpreted what a cumulative effects analysis might be and what the expectations should be for agencies. And even there, they haven't finalized exactly what it's going to look like because of the controversy associated with it. And I'm betting that well over 50% of the attention on the new Phase II rule is going to be in the environmental justice area.
Yeah.
On both sides, with advocates saying you should have been more specific. There should be reference to a health impact assessment. There should be this, there should be that. And with the folks on the other side, wait a minute, saying, this is so broad and potentially so confusing that it's inconsistent with the principle of doing an EIS in 2 years and doing an EA in 1 year.
Right.
Because in and of itself, just this one area could be so complicated and involve so much analysis that we don't know what's going on. So I think the EJ area, Nick, is going to be probably the one that gets the most. I mean, climate they'll talk about, but I think the climate side is a losing battle for the folks that are objecting. There's enough cases out there who are saying, yeah, you can do it, you should do it, just go away. Just do it.
Just do it. Yeah. It doesn't even take you that long. Just do it.
It shouldn't take you that long. It isn't that speculative. If there are things that you're not quite sure about, just tell me why. Yeah. And I'll let you, and I'll say it's okay. Just don't ignore it. EJ hasn't gotten there yet.
Right.
And the type of analysis that's an adequate one for purposes of a good EJ analysis and cumulative effects analysis, not as well defined. And I think you're going to see a lot of attention there. And then the other area in terms of the implementation is, how will folks interpret a reasonable range of alternatives now? How do they define an alternative specifically that could have fewer effects for these important resources as identified in the rule, climate, and EJ? And then the other area that I think I mentioned earlier is the regulations make very clear that the agency should do a better job in identifying the environmentally preferable alternative.
Yes.
That requirement's been in there and it's been enforced in the breach. Is that the expression? People just haven't done it very well. Yeah. Or if they had, it's a throwaway sentence, literally a sentence in the document without much to be said about it. And I think the regulations make it pretty clear that there's a reason that's in there. And there's a reason that the agency should be considering this range of alternatives, because the purpose of NEPA, one of the action forcing purposes, is environmental conservation, preservation, environmental enhancement. Right. So unless we're taking seriously the notion of the environmentally preferable alternative, we may not be fulfilling our duties under the statute. So those are some of the areas that I think are going to be, more procedurally complicated. We'll certainly get a lot of attention in the comments.
Yeah. And gosh, I mean, there's so much more we could dive into. I know, but I want to touch base with you on two more things before you go. Because again, like I said, this is the time to be when it comes to environmental policy. The other big one for me is SACIT, the SACIT ruling. I'd love for you to give a brief synopsis of what's going on now. Like I say, we just had the EPA issue its guidance based on that ruling. So what's going on with SACIT and where do we go from here?
Well, just a quick reminder of the sequence of events that we have witnessed over the last 8 to 12 months. We had the argument in SACIT in the court last October. At that argument, the federal government said, we're going to issue a final rule by the end of the year. And on December 31st, they did. They got it in the wire.
That's right.
Then everybody was waiting for the SACIT ruling. That came out, right? And it came out this spring. Yep. And it completely reversed years and years of practice under the Clean Water Act, eliminated the notion of significant nexus, and changed the definition of navigable waters, waters of the United States, focusing on navigable waters, focusing on a continuous flow of water from what they considered as real waters of the United States and other features such as wetlands and all the rest. Major change. There was no question it's a major change. And then the last shoe to drop just dropped a couple of weeks ago when EPA and the Corps, reading the SACIT decision, said, hey, guess what? We're reasonable people. We're going to amend our regulation that we issued at the end of December to reflect the SACIT ruling. We may not like it. I think they even said as much, but we're bound by the Supreme Court and we're going to honor the Supreme Court's ruling. So they issued a rule that was remarkably short.
Yes.
Remember, the initial rule, December 31st, was hundreds of pages long, hundreds of pages of appendices, technical support. This rule, 20 pages long. I gave a webinar presentation before the EPA issued this rule, Nick, and it was pretty funny. And one of the comments I passed was, I wonder what EPA is going to do now. What kind of rule are they going to issue? And my comment on that webinar was, I think they're going to take a Sharpie, and everywhere in their proposed rule where the word significant nexus appears, they're just going to black it out.
Right.
And it was a little bit of a facetious joke, but because it was obvious that was out and they had to do something about it. The question was, how much else were they going to do in light of this ruling?
Mm-hmm.
You know what they did? They pretty much took a Sharpie and just X'd out significant nexus. I mean, there's some other things, but I'm telling you, not much.
Right.
And because they took that approach, Nick, they issued a rule under the Administrative Procedure Act, special circumstances where there's they did not make the rule available for public comment.
Yeah.
This new rule, these 20 pages where they just took the Sharpie and eliminated significant nexus.
Yeah.
That's it. That's the last word on the issue from their perspective.
Right.
Now, there had been many cases pending challenging the December 31st rule of last year. They had been put on hold, obviously, because of the Supreme Court ruling and waiting for the EPA and the court to issue the rule. They've now done that. Those same litigants, a lot of the state attorney generals and stuff, they're going to run back to court. They've already said so in the press, saying, EPA, you stink.
Right.
The Supreme Court changed the way the law should be interpreted from the way you've been interpreting for years. This is a lot more than just taking a Sharpie to the word significant nexus. You didn't go far enough. You're still not getting the point. And that's what's going to be litigated now through the fall and over the course of the winter. There was 4 or 5 cases pending. I don't know which one will go first, but I expect next week.
Yeah.
Next week, there'll be a motion to reopen the cases, and there'll be status conferences, and they'll say, okay, we got to brief this all over again in light of this rule, and they'll object to using that APA vehicle for no public comment. They'll say that shouldn't have been done. We should have had public comment. They'll do that. But they'll also say, I believe, that the gravamen of the Justice Alito's decision narrowing the definition of waters in the United States was more than just eliminating significant nexus. You had to go back and look at other sorts of things. You had to look at the rule with respect to tributaries. You had to look at the rule with respect to other water features and take a sharper look, not just a Sharpie to 2 words, but even a sharper pencil to your lengthy regulation. I think it's going to be challenging for them to do that, because the Supreme Court on one hand was pretty clear, and in many ways you're not going to know exactly how the EPA and the Corps are going to implement the rule until they actually do it.
Right.
And so the issue of rightness could actually be much stronger now, because the government can come back and say, we're no longer applying significant nexus. We're going to apply the Supreme Court rule. They're saying, we're alleging that these water features are always going to be waters in the United States. And the answer is no.
Right.
We don't know that. We only know it until we see an actual permit application to see how close the water feature is to a defined water pursuant to the Sackett ruling. And sitting here, just hypothetically, we don't know which ones they're going to be. So you're going to see this whole rightness defense come up all over again, saying, that these challenges saying, you still haven't interpreted the rule right, can't be right yet because we haven't interpreted the rule in many ways. Yeah. So, that's what happened. EPA took a very, very narrow view of its obligation after Sackett. I think that ticked off a lot of the folks who were expecting, the regulation was going to shrink by half. They didn't expect just 20 pages of modifications. But even so, I think a challenge to this rule on procedural grounds that there should have been public comment, as well as a challenge on the merits, is going to be, I think it's going to be an uphill climb in this case, because I think EPA could say, look, you don't have to believe us. Believe the Supreme Court. They told us what to do, and we're going to do what the Supreme Court told us to do. What more do you want from us, court?
Right.
So it will be litigated all throughout the fall and the winter, Nick. And I'm sure there'll be conflicting decisions again, because the cases have been brought in jurisdictions all over the country. But the other thing that's going to happen now, and it's really already happening, is that individual states are going to try to figure out what they want to do. Some may want to be more protective. Some may want to go hands off. Others may want to do something in between. And so the test for you and your clients, unfortunately, or fortunately, depending on how you look at it, is that it's no longer going to be, let's use what the federal standard is and we'll abide by that. No. You're also going to have to look at each state.
It's that you took my next question right out of my mouth. That is exactly what I was going to talk to you about, because it's, seeing that, we're going to have, I'm not saying we're going to have 50 different ways of interpreting waters, but, or
we have over 20.
But yes, we're going to have a lot. So it doesn't seem like waters, for whatever reason, has always been a challenge. And I genuinely understand that it is hard to say where the line ends on where certain water bodies are and existing. And I can even understand someone saying, well, it's not here all year round. Why do I care? I understand that. But a lot of what concerns me about like the Sackett ruling and what we'll end up seeing is there's a practical reason for protecting wetlands beyond simply it's nice,
Just look at the hurricane that just passed Florida.
Exactly. It's exactly my point. So
the headlines are saying exactly what you're demonstrating. Hurricane, not as bad as people feared, because fortunately it didn't hit Tampa, it didn't hit Tallahassee, it hit the Big Bend. And what's the Big Bend? Except for a few of these barrier islands that did get inundated and terrible damage, the natural features, the water features, the non-traditional water features help lessen the impact because of the reasons that many of these waters need to be protected. So people will say from an emergency response perspective, a resilience perspective, so on and so forth. It seems to me that one result could be that the era of litigating the definition of waters in the United States is over for now.
Right.
I don't see the Supreme Court taking another case. I think they're sick of it. What I think is going to happen is that you're going to see this be tested place by place by place by place, either because there's a project and environmental groups feel that the rule isn't being interpreted as broadly as it should, or there'll be Sackett type challenges where an individual said, nope, sorry, you still need a permit. And they're going to say, no way, Jose.
Right.
And we're going to see these squabbles, play out all over the place. And then eventually there'll be a trend. Eventually there'll be some sort of trend. We hear from environmental groups that the rule is now going to protect under half of the waters of the United States that otherwise would have been protected prior to the Sackett ruling. And that may be true in theory, but the question is going to be, what does that mean in practice?
Right, of course.
What does that mean in practice? I mean, really, I don't think people are going to go in and want to develop every inch of the Louisiana marshland. On the other hand, all you have to do is look at the way Florida has been developed over the years. And a lot of marshland was developed, right?
Yeah.
So there's no way that half of the features that could have otherwise protected are at risk, because not, anywhere near half or 2/3 of that property is at risk of being filled.
Right.
It's not going to happen that way.
Right.
But what is going to happen is there are going to be specific issues with property owners, with developers, with environmental groups concerned over particular development, where the standard is going to be tested, the reasonableness of the interpretation will be tested, and we're going to have all these kind of one-off rulings here or there. People will say, oh, there's still a dispute. No, ask the Supreme Court to look at it, and the Supreme Court will say no.
Right.
They'll say, you seem to be doing pretty well at this. You seem to be interpreting it okay. We'll let you go ahead and do that. We've said all we're going to say about that. And I think that's what's going to happen. And so, again, it's frustrating for listeners, unless the listeners are consultants or lawyers, because what very well may happen is that these disputes play out technically, depending on what you say about something, and they also may play out legally if they're challenged. And so you and I will still be dealing with these and litigating these things. And, and that's not happy for most people, but I think that's how it's going to play out.
Gotcha. Yeah. And like I say, before I let you go too, I want to ask you what else you're seeing from the Supreme Court. What other cases have piqued your interest since we last spoke to you?
Well, the biggest one that we're going to have to follow is a case that the Supreme Court took in the spring. It's called Loper, Loper. Loper. It's a fisheries case. The fact pattern is kind of odd. The regulation required small fishing boats to put monitors on the boat to ensure that they weren't taking too many fish. And the fishermen objected to that. It was too onerous, too burdensome. And one of the defenses that was raised in opposition to this regulation is that the regulation was going beyond the scope of the agency's authority, and the agency should not be able to rely on what's called the Chevron principle, which defers to the agency's expertise because it goes beyond what Congress had said and the authority that the agency has pursuant to congressional action. And when the Supreme Court took the case, we weren't very clear whether they were actually going to try to reverse the Chevron principle, although that's been in the news for years as an objective for the more conservatives on the bench. But when the case was accepted, they raised should Chevron stay around, and the briefs have been filed, and the plaintiff and the lawyers representing the fishermen came right out and said Chevron should be overturned.
Wow.
And so if you believe what I believe, that there are at least 5 votes on the court to do that, maybe 6.
Right.
And you take that likely development hand in hand with the West Virginia v. EPA major questions doctrine.
Right.
You now have a 1-2 punch. You've got a left cross and a right hand uppercut to federal agencies, every federal agency. And I've already seen it. Every challenge to every regulation is raising major questions. And there have already been decisions overturning any number of agency actions saying, well, Congress didn't say so specifically, so major question, agency, you can't act. And now if the Chevron deference principle is also reversed, meaning, there might have been some vagueness in the statute, so we have to defer to the expertise of the agency. If that's overturned as well, and there's no deference when to the agency if a statute's a little bit iffy, you don't know exactly what it means, and the statute isn't specific enough to grant the agency authority, so unless it's a major question, they can't act. My question is, unless you're just updating the page numbers of a regulation, it seems like virtually everything of any importance that an agency could do is going to be subject to these challenges, and they're going to be serious challenges. They're going to be challenges that can prevail.
Right.
And so the entire principle of administrative law is going to be turned on its head by June of 2024 when the Sloper decision is handed down. I'm telling the audience now, if they want to come back and tell me I'm wrong, they know how to reach me at frwagner@venable.com. They could email me, say, you were wrong. But I bet I am not going to be wrong.
Right.
The Chevron principle is going to be overturned. There's at least 5 votes to do it. The parties are briefing it. Gorsuch in particular can't wait to reverse the Chevron principle. And so now in June of 2024, you're going to have the combination of major questions, no Chevron deference, and how are agencies going to regulate? It's nuts. And how is Congress going to react? If the interpretation of the court is basically, Congress has to be absolutely clear and there can be no vagueness. And if there's vagueness, the agency just can't, fill in the nooks and crannies. It's Congress's job and Congress's job only. Are they really going to do that? Is that something that we can expect? And so I think almost more so than any other area of law that has affected my career since I graduated, between 1987 and 2024, the ground under which we stand for administrative law is going to be completely different by June of next year.
Wow. Wow. That's so interesting. And
it's not just environmental law.
No, I was about to say that applies for a lot of different things.
It's everything. Yeah. It's every conceivable role that the federal agencies play to implement the intent of Congress in whatever area you're talking about. Economic regulation, securities regulation, employment regulation, food and drug regulation. Everything. Mm-hmm. And, when the prior administration said, we're going to deconstruct the administrative state, they weren't able to do it because they were sloppy. And a lot of things they tried to do ended up not sticking because they were reversed or they didn't do it well.
Yes.
But what they did do is appoint a lot of judges who were, very hostile to the notion of the role of administrative agencies, and they have successfully handed down these rulings that are changing the way administrative agencies work, if they could work. And that's going to be with us for years and years and years. I cannot overstate how important this is for all aspects of our economy, not just environmental law.
Yeah. And like I say, there's always a balance between, regulations and policies and, practicality. But I think, even seeing the issue with blockchain, all of the blockchain things, there's no regulation for blockchain, none, zero. So when something like losing all of your money and all of your investments and there's nothing you can do about it, there's a reason why banks have regulations. Banks aren't allowed to do that because they have rules.
Artificial intelligence, we can't keep up fast enough with what's going on.
Right.
What, are we going to wait for a regulation from the FTC? By the time they even sit down and start writing a regulation at their computer, the technology is going to change.
Right.
And so this notion of the federal government as, kind of the last stop for when things are spinning out of control from a public health, safety, and welfare perspective, where the market can't put its arms around it because things are happening too fast or something like that. The theory has always been, for most of the 20th century, that's what the federal agencies do.
Right.
If we hear about a threat, the agency can come in, they can help regulate it, sometimes in partnership with industry, sometimes not, but that's what they do.
Yeah.
And I'm telling you that the possibility of depending on that, in light of the West Virginia case and the expected decision in Loper, I don't know if that's the model that we can depend on any longer. Because there's always going to be somebody who thinks that the agencies overstep their bounds. They should have done things in a certain direction. And these two significant legal principles are going to provide, a tremendous cudgel for those parties who want to challenge those type of rules, to challenge those rules and probably challenge them successfully. So I feel for the men and women around the country in law schools trying to teach administrative law. On the one hand, it's very interesting and it's exciting. On the other hand, I just don't know what you tell people at this point.
Right.
But it's going to get harder and harder is all I can say. Harder and harder for agencies to do the things that we have seen them do for many decades. And Nick, some folks will say, good.
I know.
that's what we intended. And other folks will say, careful what you wish for.
Exactly. Yeah. I guess we'll have to wait and see. I'd say we're at time here. I guess it's always such a pleasure, Fred. Is there anything else you want to touch base on before we let you go?
Yeah, no. The big news in my household, I am now living with a retired spouse.
Hey, all right.
Yeah, I am. And so what I want to encourage listeners to reach out to me and give me great advice and give me good feedback on exactly how to manage that in my house. I'm trying to do it well, but it's a big change. It's a big change for both of us, And so I'm trying to do it right. I'm trying to be respectful and all this kind of stuff. I haven't created a big honey-do list. I have not. I haven't said, go out, you should get a part-time job. I haven't said that. But, it's going to be a big change. So,
of course,
if listeners have good advice for you to send to me or directly to me, I'd love to hear it, because it's like when you first have your first kid, right? There's no manual for that.
Right.
You just learn about it. So there's no manual for this life transition either. So any guidance and feedback would be very much appreciated.
Awesome. That's great. Love to end on that, Fred. Thank you so much for being here.
All right, Nick. See you soon.
All right. And that's our show. Thank you, Fred, for joining us today. Please be sure to check us out each and every Friday. Don't forget to subscribe, rate, and review. See you, everybody.
Bye.